For the period 67 through 71, it was generally understood that almost any topic that teachers brought to the attention of school boards was fair game for putting into a bargaining agreement. There were no rules associated to bargaining, and it was the ability of pressing an idea forward that really mattered in bargaining, and whether or not people could prevail with the ideas that they had for working conditions was really determined by how much they pressed the issue and how right they were in the issues that they chose. For example, it was not unheard of to negotiate class sizes, how large a group of individuals any one teacher would be required to instruct in a class period. It was not unheard of to negotiate rules of supervision and evaluation, and how administrators and supervisors could be held to task on performing their functions in the classroom. Almost any topic that you could imagine became bargainable at the table. Before the passage of Act 195, about 30 to 35% of school districts in Pennsylvania had achieved collective bargaining agreements, although we called them at the time professional negotiation agreements. It was probably a function of population that determined where the better contracts existed. Philadelphia, Pittsburgh, Scranton areas had been represented by the American Federation of Teachers. All the other 497 districts in the state were fairly aligned with the Pennsylvania State Education Association, although there were some exceptions. The larger cities of Philadelphia, Pittsburgh, Scranton had negotiated extensively. The more rural areas where PSEA represented teachers were less developed in bargaining. In 1970, Act 195 was passed. Act 195 was passed by a legislature that was, both houses were dominated by Republicans, and the act was signed by a Republican governor, which is something that most people today would find to be quite amazing. Act 195, which was called the Pennsylvania Public Employees Bargaining Act, was really a mini National Labor Relations Act. It had many of the same provisions. It provided for an orderly way of employees and employers to meet in collective bargaining and to hammer out agreements. The underlying effect of collective bargaining under Act 195 was to keep matters of collective bargaining out of the court system as best as possible, and that was the design of the act. There was only one provision in Act 195 which provided egress to the courts, and that was where an employer could seek to enjoin a strike by public employees, because under Act 195, strikes were legal, and they were limited, and limited only by the provision of the Act that said that a strike could be enjoined if it was a threat to the health, safety, or welfare of the public. Outside of that, there were no legal restraints to the strike itself. Under Act 195, in a practical sense, bargaining could take place in every school district in the state as long as there was a certified bargaining agent recognized. That recognition was as rapid as any process probably in the history of any law, because most every school district in the state had a presence of a PSEA local association. The state association had prepared adequately for the passage of Act 195, and it did so because there was a shift in the dynamics of PSEA. The shift in dynamics took place about 1967-68, where a previously administratively dominated organization was converted to a rank and file membership organization. PSEA's history has been, up until the late 60s, administrative membership dominated both the elected executive offices and the board of directors. In '67, first classroom teacher was elected as president of PSEA, and the shift directed PSEA toward a much more militant standpoint than it had ever had. And on March 4th of 1968, the March on Harrisburg took place, which was a grassroots effort to push the legislature into salary reform and the passage of collective bargaining in the state. And within 2 years, both were put into effect. The salary laws were enhanced by raising the minimum salary for teachers by $1,500 a year, which may not seem like much now, but in that day, the minimum wage for teachers was $4,500, and that was raised to $6,000, so the percentage was quite high. Collective bargaining became a reality, as I said, in 1970, and the law became effective in 1971. Most every district in the state had a contract by around 1974. And that proceeded on from 74 through 92, basically with no change in the law.